this is not the first time the court has encountered this type of situation. Our more recent encounter with a demand for donor information came 5 years ago in AFP. There, California Attorney General Rob Bonta sent deficiency letters to the Americans for Prosperity Foundation and the Thomas More Law Center. The first, a charity devoted to education and training about constitutionally limited government. The second, a public interest law firm whose mission is to protect religious freedom, family values, and the sanctity of human life. In his letters, Mr. Bonta sought the names and addresses of anyone who donated more than $5,000 in a single year to either group. When the organizations protested that they kept their donor information private out of concern for their donors' anonymity, the Attorney General responded by threatening fines and the suspension of each organization's status as a tax-exempt charity. So California Attorney General Rob Bonta had already tried a similar tactic. It didn't work then, and it doesn't work now. The question in this case, though, is different than the AFP case, Justice Gorsuch referred to in his opinion. The first choice case is about whether or not they could sue in federal court. Given the absence of any state court order compelling production, the district court reasoned First Choice had yet to suffer any injury from the subpoena and thus lacked Article III standing to challenge it in federal court. As I covered in my episode Unreasonable Searches, where I reviewed the oral arguments in this case, Attorney General Plotkin's argument that even though the subpoena compels the production of documents under threat of penalties, until a court orders compliance, First Choice was under no obligation to actually produce those documents. This is another ridiculous claim, but that was the basis of the district court's claim that First Choice didn't have standing to sue.